My Lords, I appear for the Claimant and Appellant, ENRC, in this matter, with my learned friends Miss Stansbury and Mr Cartwright, who are behind me. For the Serious Fraud Office, Mr Hoff, King's Counsel, appears with Mr Richards, King's Counsel, and Mr Molyneux. And for Dechert, at the end, Mr Millet, King's Counsel, appears with Miss Hurst, who I think is remote and not in court. As you know, this is the expedited appeal of hearing of ENRC's appeal against the decision of Mr Justice Waksman refusing ENRC permission to amend its claim. It's made with permission of Lord Justice Mayles, granted in April, and it was expedited, my Lords, because, as you know, the trial that was fixed in January for the Phase 2 hearing in this matter is now listed for April 2026.
Yes.
Can I just say we're very grateful for the Court of Appeal accommodating it on an expedited basis for that reason. The decision of Mr Justice Waksman, the order can be found in tab 6 of the core bundle, and the judgment under appeal is at tab 7.
Yes.
I'm going to take it as read that your Lordships will have read the skeletons and looked at the judgment, and I'm therefore not going to spend a long time opening the background of the case.
You can take it that we've read quite extensively, and certainly the matters you've mentioned.
I'm grateful. My learned friends and I have agreed an approximate split of the hearing today, so that unfortunately, I suppose you'll probably be hearing from me for most of the morning, or much of it, then Mr Hoff for this Serious Fraud Office. Mr Millet may add something, but I think may not.
We'll see how it goes.
See how it goes. Yes. And then I've been left 30 minutes in the end to reply.
Yes.
As necessary.
Can I just say, you've got there is quite a lot on the agenda,
yes.
Which is why I'm afraid we can't let the opus tail wag the hearing dog. I'm afraid if Opus's services are very much appreciated, but if they can't get things ready by 10:30, they can't expect that we're going to delay the start.
Well, there's certainly no disagreement from the claimants, from the appellant side, my Lord. That has to be right, and I'm keen to crack on as you are.
Yes.
My Lord, you know that there is an application for potential use of unagreed documents. It's really to illustrate a point that we want to make in response to a point made for the first time in the SFO's skeleton. Now, it's of such small compass and relative unimportance, my Lord, that with your permission, I'd like to deal with it if and when it arises.
Yes, well, that's I think, the preferred route.
So I'm not going to outline all of the background to the case. You'll have seen that from the beginning of the judge's judgment, where he goes through the various phases. We're now in the third phase of the trial, as you know, heading to that trial. At the first phase, which was tried in 2021, the liability phase, if I can call it that, phase 1, ENRC established that Dechert and the Serious Fraud Office were in principle liable for serious bad faith breaches of duty towards ENRC during their interactions during the years leading to the opening by the SFO of a criminal investigation. And that investigation was opened in April 2013 into both ENRC and all of its subsidiaries. We call that the criminal investigation, or CI, as you've seen, so forgive me if I say CI, I hope you know what I mean. That was the phase 1 trial, and the judge found at that point that Mr Gerard and the SFO's main witnesses, Mr Thompson and Mr Gould, had lied to the court in their evidence and were in fact guilty of bad faith misconduct. The summary of the judgment you'll find at tab 12 of the supplementary bundle. I don't need to take you to it. At the beginning of the first trial, by the beginning of the first trial, it had already been decided that issues of quantum would be hived off to a second phase, and that was called the phase 2 trial. But at the beginning of the first trial, it was also decided by the judge, my lords, to hive off causation and certain other issues of quantum, which were going to be dealt with at what became known as phase 1A, and those dealt with quantum of losses up to the termination of Dechert's retainer in March 2013, just before the criminal investigation was opened. That phase 1A trial was heard in 2023, judgment given in December 2023, and again ENRC succeeded in establishing that the wrongdoing of the defendants, both sets of defendants, caused ENRC loss in unnecessary fees paid to Dechert at that stage, before the termination of its retainer, of around £18 million. It's relevant at this point, perhaps, just to note that the judge ordered that 88% of that liability should be borne by Dechert and Mr Gerard, with the rump being payable by the SFO. That was obviously because you've seen that there are contribution proceedings going either way. Now, my lord, at that stage, at phase 1A, the judge also found that the defendant's wrongdoing caused the opening of the criminal investigation. by the Serious Fraud Office in 2013. And you'll know, both probably from the papers and general knowledge, that that investigation was one of the largest and longest running investigations in SFO history. It lasted more than a decade before it was finally closed in August 2023 with no charges being brought.
Was the investigation expressed as being just into ENRC or into the group?
Into the group, my lord, and you'll see that. I can show you the press release, quoted at least in one of our documents. It's Supplementary Bundle, tab 17, page 103. Supplemental page 103, paragraph 34, which quotes the full announced SFO investigation. Thus, the director of the SFO has accepted the ENRC for criminal investigation. The focus of PLC for investigation. The focus of the investigation will be allegations of fraud, bribery and corruption relating to the activities of the company or its subsidiaries in Kazakhstan and Africa. So it covered the whole range of companies, but it was PLC at that point that was the named suspect.
That's the same entity as the claimant.
It is now the same entity as the claimant. Following those events, the claimant delisted from the stock exchange and became a private limited company. And I'll look briefly at some point at the structure for your lordship's benefit. Now, we're now then at the third stage. ENRC is claiming from the SFO and Dechert. Well, let me rephrase that. ENRC is claiming from the SFO only at this point the losses flowing from the wrongful opening of the criminal investigation by way of unnecessarily incurred legal fees and borrowing costs over the 10 years of the investigation. The legal fees cover the 10 years, but the borrowing cost claim is limited, for practical reasons, I should say, to 4 years. That's to say for the period between 2013, when the investigation was opened, and 2016, which is when we simply stop our claim.
And that's against the SFO only?
In broad terms, yes, that's correct. And essentially, of course, Dechert's interest arises from the contribution claim that's made by the SFO against them. My lords, ENRC has always pleaded that the criminal investigation caused it to suffer loss, including by way of increased borrowing costs. And it's always claimed those costs from the SFO.
Presumably they weren't quantified at an earlier stage.
They were not quantified, my lord, at an earlier stage, although at one point during the proceedings they were estimated to be up to $1 billion, and the SFO provided in its accounts accordingly. Assessing
980.
I think it assessed it at 250 odd, being 25% of the total possible loss after contribution.
Yeah.
I'll be corrected if those numbers are wrong, but certainly they expected a very large claim, up to $1 billion. The claim, in fact, for borrowing costs, if the amendments were allowed, is actually about $91.3 million plus interest, which takes it over $100 million.
128.
Something like that with interest. Of course, the interest is quite large because we're looking back to 2013.
And you're claiming compound.
And we're claiming compound interest because we say we have to borrow the money to pay the increased borrowing costs. And you see how it amounts up. But the point is the principal sum is $91 million in borrowing costs, of which some 80 of that is at stake on this appeal. Because the 80 reflects the borrowed, the increased costs incurred by the borrowing of the subsidiary companies separately from ENRC itself.
If the investigation was into the subsidiaries as well as the ENRC, why didn't the subsidiaries have a claim for their borrowing costs?
Primarily because the subsidiaries were not clients of Dechert. And so what's happened is that the claim as it stands is for breach of the duties owed by Dechert to its client, ENRC PLC as it was. And the liability of the SFO that's been engaged is its liability for inducing breaches of that contract. And so the subsidiaries would not have their own claim against Dechert, against the Serious Fraud Office. Do not have their own claim, and no one's suggested that that is otherwise. That's
So
also
there's
why,
no,
of course,
there's
my lord,
no reflective loss
Yeah.
argument advanced
I
against.
was about to say that's why there's no reflective loss, my lord. And your lordships will have the point that we're at the stage with the amendments where no one took the point on the amendment application that there were not reasonable prospects of success, whether for that reason or otherwise.
I saw there was mention of Mareks.
Yes. Dechert raised the spectre of a future argument that there was a reflective loss problem. And it also, but didn't oppose the amendments on that basis. There is also reference to Mareks because it looks at the way losses might be transferred from one subsidiary up to a parent and within a group. And that's relevant, obviously, to one of the issues that we'll come to.
Yeah.
But they're not live on this appeal as such.
If we're looking at arguments which may or may not have been taken at the moment, what about the argument which might be run, which is often run these days in cases of increased costs, of pass on?
Of?
Pass on.
I'm not sure what your lordship means by that.
Well, if by virtue of a wrongful act, a cost is increased
Yes.
to a business, it's often then argued that the business may, to some extent, have passed that on to their own customers.
Yes.
And so hasn't suffered a loss equivalent to the increase. It's very common in competition.
Yes, I'm thinking the MasterCard type litigation.
Exactly.
Yes.
But in other cases too.
Yes, that's not been raised as an argument. Save that, the SFO might say that it's encompassed within some of their mitigation arguments or some of their quantification arguments, where they say it may be possible for us to say that you didn't suffer a dollar for dollar loss, using that as a shorthand, because you could have rented cheaper premises or you could have defrayed the increased cost through some other means.
But they don't specifically say you could have passed it on to your customers.
No, they don't. They certainly don't say that.
But that would engage quite a significant investigation into the affairs of the subsidiaries.
Superficially, it looks like it might, my lord. I wouldn't want to be drawn too much on it because I've simply never had to think about that. It's not an issue, thankfully.
The subsidiaries businesses are mining businesses?
Yes, and associated industries. That's correct.
Extractive.
Not all of them, my lord. There are, perhaps, if your lordship has, before we get too deeply into it, the structure chart that isn't unagreed at in tab 17, page 144 of the supplementary bundle. You'll see, I can just briefly outline to your lordships which companies are relevant and what their businesses are broadly.
That would be very helpful.
Page 144.
Fred, I took my structure chart out, and I don't think it has made it. Do you have a spare?
I think I will have a spare, it will be an A5 size version, my lord, if that's
Sorry about that.
Hand that up to your lordship. His team. And you'll see at the top in grey box, not the hatched grey box, the ENRC Limited UK, that was formerly the public company as I understand it. And after it became a private company, its ownership changed from January 2014, as you can see, so that it was owned by a group called the ERG Group. Those companies are not claimants above ENRC. ENRC is the claimant. Then below ENRC, you have two holding companies, actually, ENRC Finance and ENRC NV. They are borrowing subsidiaries that are relevant on the amendment application, and it's really rather important subsidiaries, as I'll explain.
That's the ground four point.
The ground four point. They don't trade, my lord. They are holding companies. They hold each other, as you can see, or one holds the other, and then NV is the predominant shareholder in various other trading companies that do exist. I say trading, some of them are mining companies, some of them are more trading companies. And the other borrowers for whom we say we should be able to claim the costs of borrowing are those in that row beneath ENRC NV, Caschrome, SSG, GPO, and so on. Caschrome and SSGPO are the predominant borrowers, and the others too. And I think you'll have the point that this is the tip of the iceberg in some ways of the ENRC structure, but my learned friend doesn't want you to see the full structure charts until we've had that debate if it's necessary. But there are subsidiaries of all of these companies, so that there are several dozen or more companies in the subsidiary category below all of these that you can see on the chart. Now, I was just saying that we've always claimed the costs of increased borrowing, and they were quantified at approximately $1 billion originally. They've now come down to, let's call it, around $100 million. Our submission is that the proposition that a listed company worth $20 billion US at the time in question would suffer some cost by way of increased borrowing if the SFO publicly announced it was criminally investigating it, ought to be uncontroversial in principle. And as I've already said, it was not just worth $20 billion at the time, it was listed on the FTSE 100. Now, on the very day that the SFO published the announcement I took your lordships to from the SFO announcing the criminal investigation, Moody's downgraded the ENRC by, I think, 2 notches, or at least 1 notch, from BA3 to B1, and placed it on a review for further downgrade. Now, our case, of course, is that there was a causal link between those 2 events. That's in dispute. But it's pretty hard to deny that it will have factored into the equation, not least because Moody's and S&P all say it did. And as I say, we are now seeking $91.3 million of increased borrowing costs, and that's less than 0.5% of the market capitalization of this company. And the company, or the group of companies, I should say, had around $5 billion in total debt during this period at the relevant times. And I'll just give you the reference, you don't need to turn it up. It's Supplementary Bundle, tab 17, page 149. That gives you the numbers. So we're talking about a very modest sum, actually, by reference to the total borrowing and the total capitalization of this company. Of course, it's a large amount of money, absolutely. And that's one of my points, of course, and why we shouldn't be shut out from claiming it. And that is, of course, why the SFO resists, and why Dechert, who is likely to be paying a chunk of it, also resists. Now, having established liability and causation, ENRC sought to reflect in its quantum pleadings that the loss it had claimed was in fact not just suffered through borrowing by ENRC itself, but also by its subsidiaries, or certain of them. And that was spelt out in what was called the Part 2 Further Information. And you'll have seen that, but I'm not going to turn it up now at tab 17 of the supplementary bundle. And that laid out in great detail the nature of the case for borrowing costs, which subsidiaries incurred them, and why it was said that the loss was what it was.
What was the date of that document?
That was served in August 2024, originally, and amended up to November 2024. And that led to the debate, the suggestion that if we wanted to run that case, we had to amend the main pleadings in the action, which only referred to ENRC's borrowing costs, and that was therefore applied for in November 2024, November last year. The applications are in each of the respective actions in tabs 18 and 19 of the supplementary bundle. Now, the point I'd like to stress at this stage, my lords, is that process leading to the application in November was all done prior to the very first CMC in the quantum phase 3 part of the proceedings. Of course, it postdated the first 2 trials, but it was before any substantive case management directions were given towards the 3rd trial. So there are no questions in this case that it disrupted or rendered wasted any part of the preparations of disclosure, or that it would require further evidence, or that the trial date itself was in jeopardy, because the trial date had not yet been fixed.
The sole answer to it, as I understand it, is the non-hold on documents. That's the be-all and end-all of the opposition. Really.
It is, my lord. Yes, it is. So, but but it's, in my submission, that it is important to bear that in mind. We're not in a, when people talk about late amendments, they often talk about case management prejudice and wasted cost and going back and doing things again. We're not in that territory. We are in the territory of there being an objection taken because a hold wasn't placed over documents, the relevance or the disclosability of which is in issue. And I'll obviously come on to that. The main two contested elements, of course, of the amendments, the issues that arise on the contested elements, are first our case that the opening of the criminal investigation in fact caused an increase in borrowing costs for the subsidiaries, not just the ENRC, and that I'll call the subsidiary borrowing costs issue, or something like that. And then there was the second element of the issues that arise that are contested, which is that whether those subsidiary costs caused a dollar-for-dollar loss to ENRC by way of a diminution in value of the subsidiaries. And I call that the dollar-for-dollar loss issue, or the DSV issue, it's sometimes called diminution in shareholding value loss. So turning to what is fortunately common ground, I can deal with very quickly, the principles on an amendment application. The essential test is, of course, whether the overriding objective is furthered better by allowing the amendment than refusing it. That's the shorter way as one can put it, I suspect. And for the purposes of assessing that question, the central task of the court is to weigh the injustice to the applicant if the amendment is refused against the injustice to the other party, or indeed to other litigants, if the amendment is allowed. And that's all to say, simply, that one is looking at a balancing exercise and which way the scales tip when you weigh the various prejudices on each side. And my lord is right that the only prejudice alleged in this case was the risk to a fair trial of the potential non-availability of arguably disclosable documents. And we can see how it was put before the judge, and I'd like to show you specifically, please, in the SFO skeleton below, at tab 34 of the supplementary bundle. That's volume 2 of the hard copies, or page 387 of the PDF. And it's really just to confirm that my Lord Justice Phillips is right, that the sole focus of prejudice, certainly by the end of the hearing, was this non-disclosure issue, if I can call it that, with a very loose shorthand. Paragraph 11.3 of the SFO skeleton on 387 of the supplementary bundle. The SFO would suffer serious prejudice if the ENRC were to be permitted to make the proposed amendments at this stage. In particular, a fair trial of claims based on alleged diminution in value would require investigation into the activities of subsidiaries, but it appears that no litigation hold has ever been put in place to ensure the preservation. So this is squarely put before the judge as an issue of fair trial. And that is based on the SFO's own evidence about this, which you'll find behind tab 24 in the supplementary bundle, page 221, Mr Whitfield's fourth statement, which is replete with references to the fairness of the trial in light of the document issue, if I can call it that. Can I show you, for example, paragraph 4.1 of page 222, where Mr Whitfield says the SFO opposes the subsidiary amendments on the basis that, and then 4.1 final sentence, permitting the subsidiary amendments to be made would pose a significant prejudice to the SFO having a fair trial. He then says there'd be this is about satellite disputes and proportionality, but that was a point not developed orally, as the judge mentioned in his judgment. Another example, but again, it's amongst others, page 230, paragraph 56, Mr Whitfield says, in order for there to be a fair trial of the subsidiary amendments, a detailed examination of the circumstances of each of the subsidiaries is required, and there is not the documentary evidence available to do so. And just for good measure, the Dechert defendants also put the objection on a fair trial basis quite squarely. Their skeleton is at tab 35, volume 2 supplementary bundle, page 412, paragraph 46, Mr Millett said there is a very serious risk of prejudice to the SFO and Dechert if the subsidiary amendment were to be allowed. That is, for the reasons set out above, that there cannot be a fair trial of the issues involved in the proposed amended claims. Now, can I, at that point, just
before you move
yes.
on, I noticed when you showed us 11.3 of the SFO skeleton, but at 11.4 there was a subsidiary suggestion that it would prejudice that complicate the hearing.
Yes.
That seems to have disappeared.
It has, my lord, and in fact the judge noted as much in his judgment. The reference to which I don't immediately have. But that, yes, it did, and it did not feature in the argument. Or
it's not suggested on this appeal, but if we were otherwise to allow the appeal, it would prejudice the length of the hearing now set for April.
No, and first of all, that would be a respondent's notice point, given that it wasn't one of the grounds the judge decided the case on. Secondly, I think it's actually now been superseded by the SFO's position that these amendments would not change the length of the trial. So it's dropped away in my submission. What I'd just like to do is, before I get into some of the more detailed elements of my submission, is urge your lordships to bear in mind that when one talks about this risk of prejudice due to the potential non-availability of possibly disclosable documents, there are actually 4 stages to that analysis which you have to explode before you can understand what prejudice might flow. And they're independent of each other. And when I say we're arguing about the risk of non-disclosure, I'd like the court to assume that I'm talking about all 4 of these elements when I mention that simple risk. The first, of course, is that one has to, before there's a risk, one has to ascertain whether the documents in question are likely to have existed at all. Is there an evidential basis to suppose that the document in question that is posited to exist actually will exist? That question always arises, for example, when opponents posit a hypothetical smoking gun or a hypothetical document that one can imagine, but for which there may not be any evidence to suppose really exists. So you have to get over that. Now, of course, there are going to be documents that exist in various broad categories, but one of the ways in which my learned friends put the point below was to speculate about the existence of possible documents that individual emails, for example, or individual communications. And the court can't give very much weight to such a submission unless it actually ascertains whether it is likely they exist at all. But even if they do exist, then secondly, obviously, the question on this sort of application is, would they be disclosable under Practice Direction 57 AD anyway? And it's important to bear in mind, as I know your lordships will, that when we talk about the relevance or potential relevance of documents, we're actually talking not about purely relevance, purely the issue of relevance. We're talking about the issue of whether they would be ordered to be disclosed under Practice Direction 57 AD, which includes the question of relevance. It's almost a sine qua non, but of course it doesn't end there. One has the questions of proportionality, of availability of the information elsewhere, and so forth. So we're not just looking at relevance, we have to ask, would these putative, unavailable documents ever have been ordered to be disclosed in the first place? If they would, or if the evidence establishes that they would, then thirdly, one goes on to ask, would those documents, or could those documents have been produced earlier in circumstances where they cannot be produced now? That's the risk of non-availability, but you have to establish there's a risk, you can't just assert it. Finally, of course, the 4-stage analysis requires you to ask at the end of that process, if all of that is true, can there nonetheless be a fair trial, even if there is a risk of such documents not being available? And that 4-stage process is, in my submission, important, because self-evidently, first of all, there can't be a risk of prejudice to someone from the non-production of documents that would never have been produced, even if the amendments had been made earlier, because they were either not there or not disclosable. And that's one of the issues we say the learned judge erred in relation to, by failing to give proper consideration to, or in fact to decide whether the documents were in fact disclosable or not, or at least to give us the chance to have that debate at the CMC when disclosure was going to be discussed. But the judge didn't even get to the fourth element of that analysis at all when one looks at his judgment, and which was the key question. The key question in the fourth element is actually whether whatever the risk is of those three prior points being established, did that putative unavailability of possibly relevant material actually pose a threat to a fair trial? And instead, the effect of his lordship's judgment was that any risk, no matter how hypothetical or small, that any document that might potentially be disclosable might also be unavailable because of the lack of a litigation hold, was enough to rule out the amendment on its own without actually considering the size of that risk and therefore the weight of the prejudice in the scales, and ultimately without considering whether that risk could be the risk exposed the fairness of the trial to jeopardy, or whether it could be overcome in any event by all of the sophisticated tools the courts have to deal with cases where evidence is perhaps lacking for all sorts of reasons. Now, on the other hand, of course, the judge did have, and it was accepted, that the prejudice to ENRC was concrete and obvious and quantifiable. Thank you, my lord. It was going to be unable to advance claims worth $80 million if they were not allowed, which were accepted to be properly arguable. And those claims had already been proven to have been generated by established bad faith civil wrongdoing on the part of the defendants. So they were claims that were half proved already, and they were very valuable, and they flowed from bad faith on the part of both sets of defendants. Now, of course, that claim, whatever its merits, is a property right recognised by the common law as such, and of course by the Convention. And ENRC's right to access the court to have it determined is a right recognised by the common law and the Convention on its merits. Now, of course, those rights are not absolute, and they bend according to the procedural rules and requirements of civil litigation in this jurisdiction. But they are reasons why the weight to be given to depriving a litigant of those rights should be very, very carefully considered.
The judge seemed to draw a distinction between the right to pursue an existing claim in the face of a strikeout and the right to amend.
Yes, if I may, my lord, I'm going to come on to a few reasons why that specifically isn't a proper approach in my submission, and examples of how it would lead to random and unfortunate, inconsistent results on substantially the same facts.
Just going back to your four, breaking down your four elements, I wonder if there isn't a 3A that you say, would they have been produced earlier and cannot be now, but I wonder whether there's a 3A that must also be shown that the fact that they couldn't be produced would be or might be prejudicial to the party resisting the amendment.
Yes, and I understand why your lordship suggests that, and whether it's a 3A or not, it's certainly part of the equation. And I was about to come on to one of the reasons why, in certain circumstances, there are types of document of that nature which can never be prejudicial, even if they're not produced.
Well, one answer may be if there aren't any documents, you can't prove your case.
Exactly, my lord. And I perceive that was what Lord Justice Mayles was referring to in paragraph 3 of the reasons he gave for allowing permission, which you may just want to glance at, because it was exactly at his lordship's point that it may be difficult to prove that we've suffered the loss, but the fact is it's the applicant who will be prejudiced by the absence of documents, because it can't prove its case. That's at core bundle tab 9, page 184.
There's also at some point a timing point, which is either the court grapples with these issues now on the application to amend, or it doesn't, in which case they don't disappear. They're still there at trial.
Well, that's very much my point, my lord. Again, I'm going to address it head on in a few moments.
We're going to look at Mr Justice Robin Knowles' decision.
In Mozambique. Is that yes, my lord? Which
at the interlocutory stage rather than at the trial.
Yes. I've certainly referred to it. I don't know whether I need to take you to it, but it's all wrapped up in those sorts of issues, and I'm going to come deal with them head on. But your Lordship's right. There is a timing problem. One of the issues that's arisen in this case is the judge said, you must prove there are no possible relevant documents that are not unavailable because of the delay, at the same time as saying, I'm going to shut you out from pleading the case. So the point at which that question can be answered never arrives. It's a sort of catch-22. I'll elaborate on that in a moment, but it's the answer. It's the point your Lordship is making. Now, so we've got that side. We know what's in...
That wasn't quite the point. The point I was making was, if you are right and the amendment is allowed, it doesn't stop the defendant from turning up at trial and saying, we can't have a fair trial.
Yes.
The evidence isn't here, you can't determine these issues, you must dismiss these claims simply on the basis that you don't have the material to decide it.
Yes.
In other words, this is not their only opportunity to
No.
take this point. The question is whether the point has to be grappled with, as the judge did now, or whether it's left over to trial and it's still available.
I understand that, my Lord, and it's a closely related point, but you're right. And of course, it's not just that the defendant has the opportunity at trial. If the amendments were allowed and we got through to the case management conference and the decision on the document review process and the disclosure process, the judge might or might not have ordered that the categories of documents that my learned friends say are required should be disclosed. If he decided that they weren't required to be disclosed, then there can't have been any prejudice ever anyway. If he decided they should be disclosed, the question would remain, will they be disclosed? Because the fact there is no litigation hold doesn't mean they're not available. It just means they're not certainly available. So one would then get to the stage of producing the documents, or whatever documents were available. And at that point, the SFO, the defendants, could say, well, now we've found that this category is not available, or that email box has been deleted. Now we know we can't have a fair trial because, and then you can actually elaborate in a concrete fashion why those documents would have meant the trial wasn't fair. And you can then apply to strike it out at that point, potentially. Or you could apply to strike out on the merits, on the basis they would say, for example, that without this particular category of document, it cannot be proven that the dollar-for-dollar loss was suffered, for example. Then they'd also have that chance at every moment between the disclosure process starting and the trial starting, and then again after the end of the trial to say, well, now you've heard the evidence, you've listened to the experts, and now we know that the missing documents were crucial to the fair trial of the case, and you can dismiss it on that basis, or it was crucial to the ability of the claimant to prove its case. But so one of the faults with respect to the judge's approach that we complain of is that he shut us out for all time from bringing this claim before analysing what disclosure was fairly required to hear it. But on the other hand, had he allowed it, the defendants would have had multiple opportunities to cure any unfairness, any injustice that the lack of disclosure might ultimately prove existed.
Well, and without actually establishing that any documents which he putatively thought might be relevant did not exist.
Exactly. Both that they might putatively be relevant and would in fact be disclosable and didn't exist, or could not be disclosed. Or importantly, my Lord, in a case like this, contained information that wasn't available anywhere else in the vast amounts of paper that were going to be disclosed. So until you have an appreciation of what's out there across the board, despite the absence of a litigation hold over certain aspects of it, in my submission, you cannot decide that a fair trial is so far in jeopardy that it's right to effectively shut out someone's case before you even ask the question.
Would you say that it's effectively elevating the concept of a litigation hold into something well beyond what can really justifiably hold? It's
almost a trump card for a defendant to resist any application, any amendment, my Lord, because on my learned friend's approach, if there's not been a litigation hold, it doesn't matter whether it's a day or a month or a year after the original claim was issued, it will always be too late to bring the amendment.
There wasn't any evidence about document destruction policies or retention policies?
I don't believe there was, my Lord, no. I don't think we're not in the realms of those cases where there are some very short, there are companies that have very short retention policies. One of the analogies I was going to make when I get onto the question of one should look at the outcome of a strikeout case versus this kind of amendment case, is where you've got a claim that's been brought by a claimant who has a 6-month document destruction policy, as some of the trading companies I've come across do. The claim could be brought 5 years and 11 months after the irrelevant events, so some 5 years or whatever after the documents were destroyed. And the court doesn't say you're not allowed to bring that and try and argue there's a fair trial. The court requires the defendant to establish that it's impossible to have a fair trial. And it does that by asking questions like, well, despite the policy, might the documents be available? And even if they're not, what alternatives might there be to deciding the case fairly? And they involve things like simply saying that the claimant can't prove its case, drawing adverse inferences against the claimant for the destruction of the documents, or whatever. All of the factors Mr Justice Knowles took into account in Mozambique, to say that one really can't answer that question until you stand back at the trial and look across the piece.
Which he in fact did at the trial.
Which he did. He did.
And drew certain adverse inferences.
Yes, exactly. So the task we say the judge had but didn't do was to actually crystallise and weigh the prejudice to the SFO and Dechert in that side of the scales. And he can't have done that job, which is the fundamental point of the test on an amendment, because he did not make any decision about whether the documents were disclosable, would not be available, and did affect the fairness of the trial. What he instead did is he said, I'm not going to get into any of that, and that led him to what we call ground 2, which is to sort of assume the potential disclosability of the material, and then in ground 1 to say we had to prove that it wasn't possible that a document that was disclosable was no longer available because of the lack of a litigation hold. So this is a double whammy I talk about. We're told we have to prove the impossible, and then the judge assumes against us that we haven't proved it.
Could he, at a CMC, I'm just wondering whether this would be a one way forward for a judge, hear argument about the amendment, and then without determining that, hear argument on disclosure on the basis that the amendment might be allowed, which would then enable him, when deciding, giving judgment on the amendment, to factor in what would otherwise be decided about disclosure?
Yes, my lord, and indeed that's precisely one of the things we suggested he do, which he declined to do because he said that's rather the wrong way round, and I'll come back to that in a moment. But there are 2 ways in which that could have played out. One is that he could have effectively answered the same questions that arose on disclosure, but literally as part of the amendment application rather than in the disclosure side part of the hearing. Or he could have allowed the amendments pro tem and engaged with disclosure on the basis that they were in, and then addressed his mind to whether the trial could be fair given his decisions on disclosure. Either option would have been available to him. And as I say, we certainly suggested that he do one or other, because otherwise you are disabling yourself from answering the question that you said the claimant has to establish at the beginning, which is that there's a potential risk of prejudice. Sorry, which the claimant has to prove does not outweigh the prejudice to itself. So that's the essence of the judge's error in my respectful submission. There are, of course, consequences that also flow from the way in which our case was a binary case, which the judge rightly accepted. Because there are cases where the putative non-availability of documents that would be or could be relevant on one party's case has simply 0 weight in the scale because it's entirely irrelevant and can't cause prejudice.
What do you mean by a binary case? You just explain that.
Yes, my lord. It's because, let me take our dollar for dollar case itself, if I may, as an example.
Well, I understand that you've said that unless you establish the dollar for dollar methodology is the correct methodology, you abandon the fact.
That's the binary point, my lord.
Yes.
It's either in or it's out. And it's not affected by the putative unavailability of a category of documents that, in our case, aren't relevant to the question. So, in order to ascertain that dollar for dollar point, we say it's not necessary to look at anything other than the documents that are, it is common ground, available to be looked at. That's our case. We say if other documents are required to be looked at, as the SFO suggests, in its categories, and the experts have this debate at trial and the judge agrees with the SFO, then our case fails. We have no case. So you don't need to look at the documents for that purpose. The actual documents are irrelevant. It's a question of methodology and principle. Either we're right in principle that these documents aren't relevant, in which case we might succeed in proving our case, or the defendants are right that the documents are essential, but they turn out not to be available, in which case we can't win our case.
Well, the documents are only not relevant if your case is that you are right that it's dollar for dollar as a matter of principle, not that you're right as a matter of fact.
Yes. That's why it's an expert issue, my lord, fundamentally, because our case is, leaving aside tax, which we've always said it does need to be looked at, but can be done because that's evident on the face of the documents that are certainly available. You're right. Our position has always been that in principle, the methodology we say can prove a dollar for dollar loss subject to tax is established and does not require you to look at the material my learned friends say you do need to look at. That's why...
That's surprising because surely it's fairly self-evident that an increased cost does not necessarily mean a diminution in value. As you say, you have the whole MasterCard line. Costs of a business may go up and may be able to pass on those costs.
Well, my lord, that's our position in our case, and that was the position before the judge. And now our point on the binary approach is that means there can't be any prejudice to the defendants if they're right. So if our experts are right, there's no prejudice caused to the defendants by the putative non-availability of certain documents because they were unnecessary for the expert analysis. So there's no prejudice to allowing the amendments. On the other hand, refusing the amendments would cause us the enormous prejudice of not being able to advance our claims and argue for them. If the defendant is right, that this exercise cannot be done without the documents they say need to be disclosed and will not be disclosed, then there is no prejudice to allowing the amendments because that debate has to happen at trial, and if they win it, the case will fail.
Was I understand that you do accept that an increased cost may be not reflected in value because of tax considerations?
Yes.
But surely that is just one example of how costs don't necessarily go through to a company's bottom line.
Well, my lord, I'm limited to what I can say about our expert case based on what we said below and what I understand my instructions to be from the experts. And my instructions on the basis on which we invite you to decide the appeal, as we invited the judge to, was that we are going to either win on the basis I've outlined or we will not. And that is because, as I understand it, there is actually a sound basis for this in accounting expertise, because the value of a company is the value of its future cash flows plus any assets, any other assets it has. And if you spend less, you spend more on cost, your asset base goes down, and if you assume you don't invest it in a negative return, the saving will increase the value of the company by at least the amount of what would have been the interest, the cost. Now, there are ways in which you can defray that. We would say they're questions of mitigation, certainly as raised by the SFO. They're legal questions about whether that cost is then mitigated, or whether it could have been minimised, or whether it's even relevant to the question. Because we would say, you ask whether the cost caused a loss, all other things being equal. That's to say, if the company acted exactly as it did, but had to spend an extra dollar on its borrowing costs, did that cause a loss up to the parent of the same amount? Now, your lordship might be saying, well, my position that all other things being equal is wrong in law, or may be wrong in law, and it may be. But I'm not arguing the case on any other basis.
Well, have you set out in any formal way what your concession is in this regard? Your concession is to the limitation on your case.
Well, I can say that it was certainly recognised and understood by the judge. If you look, for example, at Supplementary Bundle Power, page 334 in the transcript, which is the transcript of the hearing below during Mr. Millett's submission. Internal transcript, page 136, lines 8 to 13. You'll see that the judge said there to Mr. Millett, as I understand it, he, that's me, was saying if I don't succeed on my pound-for-pound methodology subject to tax, then he loses because there's no other pleaded case. He's not said independently the value of that subsidiary through any other subsidiary is diminished in some other way. And that is right. Can I then refer you to paragraph 70 of the judgment, where the judge records it in his judgment, page 176 of the core bundle, tab 7, 176. He says, ENRC does not put its claim in any other way. Accordingly, if it loses on the argument that the correct measure of diminution in value is indeed dollar for dollar, it must lose the claim in respect to the subsidiary's increased borrowing costs. The only adjustment ENRC recognises concerns the tax implications of a difference between the actual and counterfactual borrowing costs because of their effect on net profits.
So that's as a matter of your pleading.
Or a matter of the correct legal analysis of the expert methodology, my lord, yes, or however you want to put it. The point here is that you can't decide whether I'm right about that or my learned friends are right about that without the assistance of the experts and understanding precisely how the methodology works and what is said at the end of the day.
I think one needs to. I mean, we do need to understand the scope of this, because are you accepting that if it's even, if there is even a $1 diminution in your claim by virtue of something else, then the whole thing falls away?
I think what we're accepting, my lord, is that if we're wrong about the category of documentation that is needed to perform the analysis we say is the right one, and that's those categories that we've identified and no one suggests are not disclosable. If we're wrong about that and other categories of documents would have been relevant to the exercise but have not been disclosed, then we will fail.
Well, we're not now talking about disclosure or documents, we're talking about your case. And your case is that if it were to be established that in any way it's not dollar for dollar, in other words, any diminution in your claim by even $10, your whole claim goes. That's the you have to be saying that.
I think I am, my lord, but the reason I'm slightly hesitant is that
it's just a very extreme position to be taking, and one which I wonder how you're going to be held to. But that's the basis upon which we are being asked to make this decision.
it is, my lord, and I say that because it's clearly the basis on which the application was advanced below, and I don't shy away from that. But the reason I slightly hesitate is because it's not really about the financial impact of some suggested other diminution, non-diminution. It's about whether that is relevant to the exercise of ascertaining the diminution in value. Now, I agree the effect of something that is relevant but not included in our exercise might have small effect, and that would mean we lose. But it's not the size of the effect, it's the fact that there is part of the methodology that requires documents that we are saying we're not interested in for the methodology. But your lordship is right. It's the position we've adopted, and it's the position we are in. But the important point is my learned friends have to grapple with it. Because no, they do not say that it's unarguable. It's not properly arguable. And what we wanted, what my client wants, is a trial at which its experts can explain to the judge why this is right. And they have the opportunity to say, no, it's wrong. And if they're right, and it's wrong, and that means that we fail, then they haven't suffered any prejudice. They've just lost.
So we're not looking at a counterfactual here, are we? We're looking at what actually was the diminution in value.
Yes, exactly.
And so we know what the increased borrowing costs are. We assume that those will be established.
Yes.
And one then has to look at what effect did that have on the value of the company.
Yes.
And on the face of it, one would expect that any factors that might go into the valuation of the company as a result of having an increased cost would be relevant in that exercise. You're saying that no factors are relevant in that exercise other than the mere fact that there's an increase in cost.
That's what our expert case,
Except tax.
as I understand it, is, yes. That's what we said before the judge. And that's what we say now.
Well, there we are. I think we've teased that one.
But my lord, that's why the judge, with respect, was wrong. He understood that point, that we had this binary case. It was an all or nothing case, that our methodology was either right or it was wrong. But he then said, in paragraph 73 of his judgment, but the other side will still need to see documents to challenge that approach. That's 73, page 176 to 177 of the core bundle. Now, of course, that was an error. It was an error in two respects. First, because you don't need to look at the documents to argue about whether the methodology requires the documents to be there in the first place. This is an argument of principle or methodology, not a question of what's in the documents.
Well, we haven't seen the expert evidence yet, have we?
No, we can only surmise what it said. But my lord, that's why it's not right to preempt the trial of the expert issue, where we say if we're right, there's no prejudice to the other side, and if we're wrong, there's no prejudice to the other side. But the other reason the judge was wrong in paragraph 73 was because he actually assumed the lack of documentation, which of course is not established. That's the first full sentence on page 18 of the judgment, page 177 of the bundle. He said, they'll need our documents to challenge or to explain why the dollar-for-dollar approach does not work. For that reason, the lack of documentation now at subsidiary level constitutes a real prejudice to the Dechert defendants. And that was on any analysis, an overstatement, because no one's established a lack of documentation at all. But your lordship's right that binary case arises in a sense because it's about methodology or possibly law, or the mixture of the expert issues and the law. It doesn't depend on establishing a factual counterfactual or factual assumptions. If you're in the territory of any other kind of question that arises, and let's, for example, the first question, did the subsidiaries actually incur increased borrowing costs, leaving aside whether that was felt dollar for dollar up the chain, then my learned friend says, well, there could be out there somewhere a document that is relevant to that question that isn't available in the disclosure. And he says that means that there's a serious risk of...
Well, you say that's speculation.
Trial, and we say it's speculation. But the point, my lord, is, whatever it is, the judge didn't weigh it. He didn't attempt to say, there is this likely possible absence of material, it is relevant and will be disclosable for these reasons, but it won't or may not be available because of this reason, and the lack of it means a fair trial can't be held. And if you don't actually weigh or size this prejudice, because it could be infinitesimally small, it could be larger, you don't weigh it, there's nothing to weigh in the balance, and that's the error of principle. That the judge identified the right test, but didn't put anything in the scales because he didn't analyse the issues. And that led him, as I said, to what we say was the error in ground one, which I'll just show you the quotes, if I may, from our skeleton argument at paragraph 45, page 12. Because these issues weren't going to be decided, he in fact held us to the tests that we've set out in those quotes in 45. He said, I cannot say for sure on the amendments application that at least some of the documents sought might not be relevant. And I don't think it's right to conclude that none of the documents which would have been caught by a litigation hold on subsidiaries could be relevant.
Ariso, where are you looking at now?
Sorry, my lord, paragraph 45 of my skeleton argument.
Thank you.
Page 12. And the effect of setting the test at that level was to mean that the defendant merely had to posit the hypothetical possibility, no matter how small the possibility, that an arguably relevant document was not subject to a litigation hold, then the amendment would be refused.
Well, the answer, the other side put to this is they say that this is to misunderstand what's happening here, which is that what the judge was doing was answering your, as it were, extreme contention that no documents.
Yeah. Yes. The reason that's not the answer, my lord, is that was not our submission. We said we can disclose all relevant documents. Or all, what we meant, of course, was expanding that. We can give disclosure of sufficient documentation to enable a fair trial of these issues. We never set out to prove, and no claimant in my client's position would ever have set out to prove, that there was no possible document it might not be able to disclose that could possibly be relevant. So that is not the right answer to the question to this point. And I come back to the point, my lord, that even if we had set out to make that submission, the judge had to weigh the prejudices, including ultimately the fourth stage of the prejudice to the defendants, which was whether there was in fact a risk of an unfair trial at all. And that, when you look at the judgment, does not come into the judge's analysis at any stage. And it might be in his conclusory part. And it might be notable, perhaps, to look at paragraph 43 of his judgment, core bundle, page 169, tab 7, page 169, because, in fact, when he's reciting the defendant's arguments, you can see the error the judge slips into at the end of paragraph 43, because he aligns the question of fair trial with the question of proper disclosure. So he says, these are the SFO's submissions summarised. First, no litigation hold. Therefore, there is a risk at least that the trial of this issue will not be fair. Or to put it another way, the SFO will be prejudiced because it will not have had proper disclosure. Now, I don't want to push this too far, but what the judge appears to be doing is to forget that there are all sorts of ways in which the court can have a fair trial without disclosure of all documents. But because he treats them as synonymous and assumes there won't be documents available that should have been disclosed without deciding it, he never actually asks whether, in fact, the risk of that happening is such as to jeopardise a fair trial. He just assumes it would.
This is just a recital of the SFO's submissions.
I don't think the last sentence, my lord, is fairly described as such, because I think the judge is actually paraphrasing what he takes from the submission. But I may be, if someone can correct me and say that's actually exactly what they said, but I perceived what the judge was doing. We say, well, you're saying there's a risk of no fair trial. I equate that with prejudice due to lack of disclosure, and that does not follow. But anyway, it's a small point. So, if I can just move on to ground 2 briefly, separately. We've covered the ground to some extent, because what happened there is a sort of cart before the horse problem in our submission, and it pervades both of the judge's reasoning on both issues. What he did was assume that there would be disclosable documents in the categories that the SFO described that were not subject to a litigation hold, without in fact engaging in the question. And that, we say, is not a principled approach, because apart from anything else, it doesn't take into account key parts of that 4-stage analysis that I've outlined. And the judge recognised what he was doing at paragraph 64 of the judgment. I've just shown you 70 something. If we go back to page 174 of the bundle, page 15 of the judgment, the judge has set out at this point the documents we say are relevant to the issues, and the documents the SFO says will be relevant to the issues. And our submission was that the SFO's argument about how many documents you'd need, this is 64 of the judgment, was wrong. The judge says essentially our response was to say this cannot be right. It's appropriate if you start from the ground up, but the exercise here is different, he says, because it's to ask the difference the CI made to the actual lenders in terms of the deliberations. And then the key point here, I follow that, but without any more detail, I cannot say for sure that at least some of the documents sought might not be relevant. I've read that to you before. And it is difficult to be sure where we have not yet had a hearing on the disputed items on the DRD. So what I'm being asked to do now by ENRC is effectively to decide that dispute in advance for the purpose of the amendment application, which does seem rather back to front to me. And that comes back to my Lord Justice Phillips' point, that we were inviting him to decide the disclosure point, so that that would inform his decision on the amendment. But having failed to decide the disclosure issues, it was unfair and unprincipled of the judge to rule out the amendment because he couldn't possibly ascertain the true weight of the prejudice, if any, to the defendants of allowing the amendments at that point. And if you don't do that exercise, I ask rhetorically, my lords, how can the judge have weighed the prejudice to the defendants against the prejudice to the claimant if he doesn't actually ascertain whether the documents are likely to be disclosable in the first place, i.e. who's right? And that's what I meant when I said a moment ago that the judge's approach led to a double whammy, or a catch-22 at least, for ENRC. It was told, this is ground one, that in order to satisfy the court that the amendment should be allowed, we had to show there was no possibility that proper disclosure could not be given. But the court, ground two, was not prepared to ask or answer the question of what disclosure was required or available to be given. So our case was shut out before the point in the proceedings at which those questions could be answered, namely the disclosure stage, the judge refusing to entertain them at this stage. And therefore, and of course, by the time the disclosure stage arrived, the claim had been shut out. And so the question never arose and we couldn't answer it. And our case, in short, my lords, is that the only appropriate way to proceed, if you have decided not to engage in the disclosure issues, as the judge clearly did at the end of paragraph 64, the back to front point, the only fair and appropriate way, principled way to proceed, was to allow the amendments so that the question on disclosure could be asked and answered. At which point, and as I said to my lords earlier, at any point thereafter, of course, the issue of a fair trial could be revisited whenever the defendants wished.
Well, the other way round you put it, effectively, is that what this amounts to saying is that wherever you apply to amend in circumstances where there was no litigation hold over documents which might then become relevant, you cannot amend.
Yes. And of course that has real serious repercussions if limitation is an issue or if other issues, if matters come into play as to why you can't just issue a fresh claim. It might even be said to be abusive, as my learned friends posit. So that,
but you couldn't issue a fresh claim here because it's the same cause of action. You can't sue twice on the same cause of action.
Even if you could, my lord, limitation would be an issue. But one sometimes does see parallel claims arising out of substantially the same action, cause of action, or at least what's said to be a different breach of it, and then they're conjoined. But it doesn't particularly matter. The point is that the effect of our not being allowed to amend in this case is that this claim cannot be brought at all, ever. My learned friend's retort to the point I've just made about the judge not engaging in the disclosure question because it was rather back to front is, well, we invited him to deal with the amendments before the CMC, or the disclosure element of the CMC. But of course we did, my lord. Of course any litigant would have, because you have to know what the amendments are before you can actually decide the disclosure. The only alternative would be, as my Lord Justice Phillips said, decide the disclosure as part of the amendment application. And that's what we asked the judge to do, and in fact what the judge recorded us asking him to do in paragraph 64. So the idea that by if you like, setting out an agenda that had the amendments at the top and the disclosure lower down, we somehow made our own bed and now have to lie in it is misconceived, because in fact, as part of the application, we invited the judge to grapple with disclosure, and he refused to do so on the basis of back to front.
Can you give me the reference to where in the transcript you invited him to do that? Not necessarily now.
Certainly, I can't do it now, my lord. I'll have to ask my juniors to dig that out. I should say, my lord, in anticipation in any event, but whatever the transcript says, of course, once the judge had decided not to answer the question of disclosure, whether he was invited to or anybody had asked or not, it vitiated his reasoning in principle anyway, because once he'd ruled it out as being back to front, he disabled himself from weighing the very prejudice that had to be weighed in the balance. And so that is the core of the error. And as I say, it led to the catch-22, which we were not given the opportunity to satisfy the judge that we could give disclosure for a fair trial, but the result of not being given that opportunity was that the case never proceeded to the point at which we would have had that opportunity. And the various bites of the cherry point that I made earlier on the part of the defendant, counterbalancing the prejudice. Because if there is any prejudice or any latent or putative prejudice from the possible future absence of documents, that prejudice does not weigh very heavily in a balance where the question of whether there can still be a fair trial can be raised at multiple future opportunities. It's a one.
What it comes down to, isn't it? What you're saying is the judge has effectively ruled out the amendment, even though he must necessarily accept that there may be no prejudice.
Yes, that's at the fundamental heart of ground 1 and 2. By doing the way he did, he squeezed us between a rock and a hard place to know where to actually decide whether there is prejudice.
My understanding of the respondent's answer to ground 2 is to say, well, you tried to persuade the judge that there was no prejudice because of your dollar-for-dollar point. And the judge was simply addressing that and saying, I can't reach that conclusion. I can't say there's no prejudice. If that was all he was saying, there's nothing wrong with it, see? Because I think you accept that he couldn't decide on this application whether there would be prejudice or not.
Not quite, my lord, because if on the dollar-for-dollar point, because of the binary nature of the case that he understood us to be making,
Yes.
he could decide there was no possible prejudice. It's on other aspects of the case where factual issues arise that there may be a problem. But on the dollar-for-dollar, no, he was perfectly able and should have decided there was no conceivable prejudice at that point, because we were either right or wrong, and documents wouldn't have changed that. So that answer doesn't work on that basis. And as I say, the reason it doesn't work on any basis is that the judge didn't decide that there might be documents out there that would be disclosable in due course that were not available. And unless you decide the weight of that risk, or the existence and weight of that risk, he could never have performed the balancing exercise he was required to perform. And that's why we say, at the end of the day, when the complaint that is made on an application like this is about the absence of disclosure, the possible absence of disclosure, the risk of non-disclosure, there has to be some coherence with the court's approach to striking out a case on the basis there's no fair trial possible. Because ultimately, the reason why disclosure matters in this situation is the defendants say there could not be, or there was a good high risk of there not being a fair trial. But on strikeout claims, of course, even where documents are unavailable because the claimant has deliberately destroyed them, it will not be assumed that a fair trial is not possible. That is a question to be decided in all the circumstances, bearing in mind the tools the court has to plug evidential gaps and all the other matters that I've raised in comments I've made to the court already. So you can posit various hypothetical alternatives. Imagine the ENRC had brought a fresh claim a month or so after its original claim to plead the subsidiary losses in a separate claim. Now, assuming they arose from a different cause of action, a different breach, perhaps, but leaving that to one side, that claim, if it was a good one, would have been able to be brought as of right, whatever the state of the litigation hold. And it would then be case management, no doubt, with the existing case. But in order to suggest that the lack of documentation rendered that claim worthy of not even being tried, the defendants would have to show that a fair trial was impossible. And the authorities we cite in paragraph 50 of our skeleton show that even where it's deliberate, it's still not a given that document destruction will render a trial impossible. Now, we say it would be unprincipled if the self-same claims couldn't be introduced by amendment simply because the defendant could show there was a hypothetical risk of unavailable documents, because there would be no parity between two substantively identical scenarios. You can also imagine, my lords, the situation where ENRC had issued its claims originally, including the subsidiary amendments, as it's now suggested. But the claims were brought many, perhaps years after the relevant events, and years after they could have been first brought, potentially. No litigation hold over any of them in the meantime, as is suggested now. Well, clearly, in that situation, there would be a real risk that documents, disclosable documents, have no longer been retained. On my learned friend's approach, let's assume that risk exists. But ENRC would have had the absolute right to take those claims to trial, unless the defendants could establish on a strikeout application that a fair trial was impossible despite the lack of litigation hold. And again, why should the answer to those two scenarios, to that scenario versus our scenario, be diametrically opposite when no one's actually decided whether a fair trial is possible? And certainly, in my respectful submission, the question of whether a claim should proceed to trial must be addressed after the scope of disclosure has been decided, and once it is clear that documents are in fact unavailable or available from various sources. Not before, because unless that question is answered, it is impossible to weigh the risk of prejudice to either side, or I should say the prejudice to the defendant. Can I come on to look at that is in essence our case on grounds 1 and 2. And I'm not going to separately develop ground 5 on lateness unless I have time available at the end. My learned friend says it all goes in with ground 1 because it's essentially questions about the test to be applied. I'll say a few things about lateness if I have the time. But I'd like to focus next on ground 4, if I may, because it's a substantive and important aspect of the appeal. And it raises different questions from those that we've addressed so far. The ground 4 arises, as I said at the beginning of the submission, in relation to what I'll call NV and Finance, the two holding companies at the top of the chain. And it arises whatever the position in relation to ENRC's other subsidiaries and their borrowing costs. They are clearly, NV and Finance are clearly and distinctly in a very different position from the others. Both because of their position in the hierarchy, their holding companies directly underneath the ENRC, but most importantly, because there was a litigation hold in place over their documents. And for that purpose, I just need to show you paragraph 69 of the judgment, if I may, on page 175 of the core bundle, where at paragraph 69 the judge says, he was initially disposed to allow these amendments, at least in relation to NV and finance, because they did not face the same problems as the amendments relating to the other subsidiaries. Because there was here, in effect, a litigation hold. So it's not capable of dispute now, although I accept that that finding needed certain development from the initial evidence that was served. But the judge ended up satisfied that there was, in fact, a litigation hold over NV and finance. Now, my lords might ask, well, why isn't that the end of the matter for NV and finance? The whole debate, the whole dispute arose because the defendant said that if an entity who borrows money is said to have paid more for the money, it needs to disclose its documents in order to make that claim good. Now, the objection to the subsidiaries was always that they didn't have a litigation hold. But we then find that NV and finance do have a litigation hold. And that ought to have been the end of the case. Of course, the SFO and the Dechert have to slightly move their position. And they're now saying that to assess a company's borrowing cost increase, you have to look at its sub-subsidiaries. And I'll explain in a moment why they've never said that before. They're not saying it in the present claim as unamended, and it's wrong. But the way the judge dealt with this, I should say, by way of a preface, this claim alone for these two subsidiaries relates to $35.8 million worth of lending, of borrowing costs. This is not small on its own, and it's totally separate from the others. And nonetheless, in refusing these amendments, in relation to the subsidiary borrowing cost issue, the judge relied on an argument that hadn't been made by the defendants, which we hadn't therefore answered and which was wrong anyway, and I'll come on to that in a moment. And in relation to the dollar-for-dollar argument, he simply didn't address the point at all. And that's before one gets to the binary nature of that case anyway, but I'll deal with that separately. So as for the first issue on the amendments, the subsidiary borrowing cost issue itself, the argument that the judge himself alighted upon to dismiss this claim is in the rest of paragraph 69. Can I ask you to just look at the penultimate line on page 175 of the core bundle? The judge said, however, on further analysis, that's to say, despite the litigation hold, that is not an answer to the problem, because if, as ENRC says, they're both mere holding companies, then the documents which would be relevant are those of their indirect subsidiaries, which of course takes us back to Caschrome, SSGPO and the rest. And those are the companies over which it is said there was no litigation hold. Now the first thing to note, my lord, is that word indirect. No one had ever suggested, on the defendant's side, that one would need the documents not of the subsidiary that borrowed the money, but of its subsidiaries in order to fairly try the case. And there's a clear and straightforward answer anyway, and that is that the SFO, in fact, and the Dechert, on the contrary, accepted that all they required for a fair trial were the documents of the borrowing company itself. That's to say, of NV. For NV, you'd need the documents of NV. For finance, you need the documents of finance. For Caschrome, you'd need the documents of Caschrome. And one can see that clearly from two different angles, if you like, or two approaches to the point. If you look at what was being said at the time of the application itself, the SFO made this very clear in its argument. So if you look at the skeleton, which is tab 34 of the supplementary bundle in volume 2, at page 387, paragraph 11.3, line 2, which I've already read to the court, you'll see that the SFO's position was that a fair trial based on the alleged diminution of value of the subsidiaries would require investigation into the activities of such subsidiaries, but it appears that no litigation, such subsidiaries, of course, is the borrowing subsidiary, by definition in that sentence, which would require investigation into the activities of such subsidiaries, but it appears that no litigation hold has ever been put in place to ensure the preservation of relevant documents held by the subsidiaries in question. So there's no doubt what they were suggesting, and the same points bottom of the page in 12.1 over onto page 388 in paragraph 12.1388, an ultimate sentence. The question of how a subsidiary should be valued would be a matter for expert evidence, but on at least some potential approaches to valuation, detailed information about the affairs of the subsidiary would be relevant, and the subsidiary's own documents are likely to be important. So we're talking about the valuation of the subsidiary said to have borrowed at increased cost, causing a diminution in value to ENRC. And finally, if I can try your patience with one more, my lords, at 12.3, from line 4 on that page, in order to assess the impact, if any, which the CI had on any particular subsidiary's borrowing costs, the party's expert will require information about the subsidiary's attempts to raise finance, internal decisions, the assets the subsidiary had by way of security, and reputational issues. Documents relevant to those matters are likely to be held by the subsidiaries which are said to have suffered increased borrowing costs. So it's absolutely clear that until the issue of the litigation hold evaporated for NV and finance, my learned friend's experts and its evidence only suggested that you needed the documents of the relevant borrowing company, not any sub-subsidiaries or indirect subsidiaries. That's the one angle you need to look at this from, if I may say. The second angle is to ask, well, now that prior to the amendments being posited, and since the amendments were disallowed, what disclosure has the SFO said is required to prove or to test whether ENRC's borrowing costs increased? Because if the SFO's approach now is right, they would have to look at the various subsidiaries documents of ENRC, the trading subsidiaries, in order to work out ENRC's increased borrowing costs. And don't forget, my lords, that NV and finance are functionally in an identical position to ENRC, because they're all holding companies at the top of the chain. But the status quo, my lord, is that the SFO has never once suggested that for a fair trial of the increased borrowing cost claim brought by ENRC itself, any subsidiaries documents are even relevant, let alone necessary.
But there's a fundamental distinction between your claim in relation to your own borrowing costs and your claim in relation to increased borrowing costs of subsidiaries, including NV and finance.
Yes.
And your diminution in value claim potentially brings into play the position of the sub-subsidiaries.
Your Lordship's right that that is a point of distinction. I'm going to come on to it. What I'm addressing at the moment is the suggestion, which you've seen made here, that for the first issue, you need the subsidiaries documents. Leaving aside the dollar for dollar, I'll come back to. And there is an answer to that. It's quite straightforward. And one I would have given to the judge if I'd known this point was coming. But the point cannot be different as between ENRC itself and NV and finance if all of their documents are subject to a litigation hold. And the issue is, did they suffer increased borrowing by reason of the criminal investigation? Because no one's ever suggested you need to look down below them to answer that question. And I take your point that that means there's a dollar for dollar question that needs answering. But the position today, my lord, is that the SFO has not attempted to suggest that we need to harvest or search any subsidiaries documents for the present claim. So it cannot be the case that it goes to the issue of whether there's been an increased borrowing cost. Now, on the dollar for dollar approach, the judge didn't even address how this was affected by the litigation hold point. And that is, we say, an error. What he did was assume the lack of documentation at paragraph 73, which you'll see on page 177 of the core bundle, where he's dealing with the dollar for dollar issue between paragraph 70 and 73. And it's premised on the lack of documentation at subsidiary level. So that the error, of course, is that he had earlier recognised that that statement did not apply at all to NV and finance, because their documents had been subject, in effect, to a litigation hold. Now, at the time of the application, my lord, this goes back to the first way of looking at the thing, the SFO had never suggested that for the dollar-for-dollar approach, you had to look at subsidiaries documents for the purpose of ascertaining whether that is right or wrong. So when the subsidiary amendments were on the table, the SFO still did not suggest that the subsidiaries documents would be relevant to the dollar-for-dollar point. Until now, trying to support the judge's conclusion, which was actually made in relation to, not to the dollars-for-dollar point, but the factual issue that arises at the first stage in paragraph 69 of the judgment, that in fact the answer to this is that you still need to look down through to the subsidiaries, the indirect subsidiaries. So that's not the judge's answer, but it's wrong anyway, my lord, because in my respectful submission, one only has to give it a relatively short period of thought to see that the dollar-for-dollar issue looks upwards from the relevant borrowing company to ask whether the dollar-for-dollar loss felt at the borrowing company level is felt at the parent company level. You're asking what losses flow up from NV or finance to ENRC to ask whether there is a reason that the operations of or the business of NV and finance means that that dollar-for-dollar doesn't apply. You cannot possibly need disclosure for dollar of documents that look down into the subsidiaries of the subsidiaries. And that is why I respectfully submit the SFO never suggested you did.
But if you're right about dollar-for-dollar, you say we don't get here.
You don't, absolutely, my lord. That was my final point. If I'm right about that anyway, it doesn't matter. But I have to grapple, therefore, with what the SFO now say is the answer to that point, because I can take each in turn and actually explain why they failed to answer our case.
Your dollar-for-dollar argument is a lot simpler than a pure holding company, which just receives cash flows, one hopes, from its subsidiaries and passes them up.
Yes. That's part of the answer. That's part of the point, my lord, exactly. And it's another reason why it was wrong a fortiori to exclude NV and finance from the amendments, because they didn't engage complicated issues of the same nature on any basis. Whether 100% holding company that also holds other companies borrows more, whether that cost affects the parent company that owns 100% of it, is a much more straightforward question.
It's not a trading company.
No.
My lord put you that if a trading company increases its costs, there's all sorts of things it might do in reaction to that.
Yes.
But that's not obviously the same.
No. But your lordship's right. Of course, I reserve my position on the actual mechanics of it. But your lordship's right. But that distinction with NV and finance was never grappled with by the judge. It doesn't come into his thinking. And there isn't an answer to it in my respectful submission.
But just trying to understand this, all of the subsidiaries and sub-subsidiaries are owned through the chain, which includes finance and NV.
Yes. And
so,
ENRC, yes.
Yes, at the top is yes. So all of that is encapsulated within your only claim, surely, can be for the loss, the diminution in value of finance.
Ultimately, that's probably right, my lord, because you're looking at the diminution in value at each step of the chain and how it feeds into the top.
But you can't claim separately for the loss of value in SSGPO.
No, I think that's right. But of course, you have to ascertain the loss that travels from one company to the next before you can move it up the chain.
But that undermines your dollar-for-dollar argument.
Well, if my experts are wrong, that one does need to look down, your lordship may be right, but that's
well,
not...
Say SSGPO has its borrowing costs increased. That can't be a dollar-for-dollar loss for you. That's got to be a dollar-for-dollar loss for finance, hasn't it? Or in fact for
Well,
NV,
it goes to NV first. But my lord, I see what you're saying, of course. The question, though, is whichever level of the chain you take it, you have to work out what ends up with the ENRC. So it has to come through a diminution in value of
Well, there's only one.
finance.
There's only one relevant company that you hold here. You only have one relevant shareholding, and that is in finance. So your claim can only be for the diminution of that shareholding. And in order to work out what that is, you may have to work out what the diminution of finance's shareholding is in NV is, and what NV shareholding in SSGPO is.
You might for SSGPO's borrowing costs, of course, my lord, on one view of the world, but not for monies borrowed by finance.
But you cannot claim SSGPO's. That definitely is reflected loss, isn't it? You can't claim the diminution in value of SSGPO because that reflects into finance, which you are claiming the diminution in value. You can't have them both.
I do agree we can't have them both. My lord, we're focusing at the moment, though, on NV and finance, who both borrowed money on their own account, which we say was at a rate higher than it would have been but for the criminal investigation. So can I just take it step by step, perhaps, and look at finance, directly owned by ENRC as to 100%. If we are right on the first stage of the analysis that finance's loans were more expensive because of the criminal investigation, then one gets to the second step, which is, does an increased dollar cost to finance feed through to an increased dollar for ENRC? And that does not engage any question about what's happening below finance,
No.
even if other companies do.
Can I put to you this? As I understand it, the issue at trial is not going to be it's going to be a causation issue. Was it the criminal investigation which made your group's borrowing more expensive? Well, you have to show, firstly, they were more expensive, and secondly, it was the criminal investigation rather than anything else.
Yes.
There could have been all sorts of things which it might be suggested to increase the borrowing costs. There might have been political turbulence in Central Asia. There might have been risks of expropriation. There might have been misreporting from the mines, all that sort of thing.
Yes.
Any lender is going to be interested in what the actual cash generating parts of the group are doing, whether there's how secure their future income is.
Yes. And
So is the judge not right in saying, if you're asking why are finances borrowing costs higher than their competitors, one answer might be because of the criminal investigation, but another answer might be all sorts of things going on at the subsidiaries level.
So first of all, my lord is moving away from the dollar for dollar point, completely understandably, and I just want to make it clear that this is now a different question.
This is a different question.
This is a question goes to the costs of borrowing, what caused them.
Yes.
Absolutely, my lord.
Well, that's presumably going to be the main issue at trial.
Well, it is a big issue, yes, that's right. And that is where the party's position on disclosure was set out in the evidence before the judge. All of the material, first of all, there are two important things to bear in mind here. Just jump ahead, if I may, to what was clear on the evidence. At all of the relevant loans, even those nominally in the names of the subsidiaries, were negotiated by the head companies.
Yes.
So the lenders were negotiating with ENRC or ERG people, if you like, at the top of the chain, and the evidence established that all of those communications will have been captured and preserved.
Yes.
So anything that the lenders were actually interested in and asked for will have been within the litigation hold and will be disclosed, or have been disclosed. And there are some, one can just turn up an example, if you like, at supplementary bundle page 275, because it is quite relevant to your lordship's question in some ways. 275 is the exhibit to Mr. Roberts of ENRC Solicitors' 18th witness statement. And this is an example of what is in the disclosure from the held material. And it's an email from one of the lenders, Sparebank, to a lady called Miss Yesmakanova at ENRC, that's to say the head company, about the documents that the lender wanted in relation to a loan to a subsidiary. It made good the point that what the lender was asking for and what it was interested in will be within the disclosable documents, those over which a hold was made. But it also makes the point, my lord, that when you're asking why did the lender lend at this or that rate, either they did so on the basis of information in the public domain or research or ratings agency reports, which are all disclosable or accessible anyway, and they're all out there. Or it made reference to its own internal materials, and of course we don't have them, but nor do they, and they can't complain that we haven't got a litigation hold over them. They've never asked, as I understand it, the lenders to disclose them. Or they will have asked us for them, and those communications asking for them and providing the information are all disclosed.
So if they wanted to know what the next 5 years projections of the a particular mine in Kazakhstan was, they would have asked you for it.
Yes.
And you would either have provided it or not. But the fact that you can't anymore, possibly can't anymore, ask the subsidiary for it doesn't matter.
No, that's right, my lord. I'm sorry you just put the bundle away, because if you just turned on to page 280, you would have seen an example of a contemporaneous document sending back the audited accounts of the subsidiaries themselves. So the negotiators, they are clearly interested in the subsidiaries. There's no question that a lender would be interested in the cash-generating elements of the group. It goes without saying. But that isn't relevant for today's argument, because it was all subject to the litigation hold that covered the parent group, parent communication. So that's 280, tab. I don't know, of the 29 of the bundle. And it's in the same chain, I think, as the one I showed you earlier. But you can see what happens is the lender communicates with the head company about, effectively, the financial standing of the subsidiaries. And that's not very surprising. Now, my lord, just finishing off that point, whether or not it's, or the extent to which it is relevant to look at the characteristics or operations or whatever of the subsidiaries, there is, in my respectful submission, absolutely no way a judge trying to try the question of whether NV at the top of the chain had to borrow more money, had to borrow at a higher cost, would have started ordering disclosure of the 50 or 60 subsidiary companies way down the chain, all of which could potentially illuminate the overall position of the company, but would be a wholly absurd and disproportionate exercise.
And you have the full group structure, and it's disputed about whether we should see that.
Yes, but in a way, my lord, it can't be disputed that what you've seen is the tip of the iceberg, and that's really all I need to show you. But if you really want,
really, why we shouldn't see, unless its accuracy is disputed.
I think the SFO say they can't vouch for its accuracy or can't test it. Of course, that's probably true within the confines of an appeal, but it's put forward by my clients in good faith, and it comes from their records. But I'm happy for your lordships to look at it de bene esse or not, but in a sense it really doesn't matter, even if the only subsidiaries were those on the sheet that your lordship has seen. The exercise of looking at either ENRC's borrowing costs or ENRC NV and the ENRC Finance's borrowing costs would never have involved the large wholesale disclosure of documents held at the subsidiary level, even if they'd been subject to a litigation hold. But my lord, that begs the prior question which the judge didn't decide, which of course is, well, would they? Until you've decided that they would have been disclosable, you can't possibly weigh in the balance of prejudice the fact that they might no longer be entirely available. And we're back to the points on grounds 1 and 2. That was a slight digression to really explain, for my lord's benefit, that when you're looking at when the judge was looking at the question of what was needed to look at the causation, for example, there were two competing theories. The claimant's theory that it could give disclosure of the documents that were necessary, reasonably required for disclosure of that, on that issue. And you've seen, I've shown you some of those, because they are subject to litigation hold, and they were all negotiated at group level. The SFO's worldview, said to be informed by their experts, which is that essentially you have to model from ground up each of the subsidiaries in order to work out the value of each of the subsidiaries that feeds into the larger picture of the characteristics of the group, both in terms of whether there was causation of the criminal investigation or the dollar-for-dollar analysis. Now, our argument was that was wholly unrealistic. But the real point isn't that your lordships can decide that now. The point is that unless that is decided, you can't make the submission that there are documents available that will not be disclosed. Sorry, there are documents that would have been available that can no longer be disclosed. Because it's an antecedent question the judge didn't answer. So that was a kind of long-winded way of picking up your lordship's point, but I think it's covered a bit of the ground I wanted to look at anyway. We were, I think, in the middle, though, of looking at the question of whether the dollar for loss disclosure for NV and finance specifically and only would require any of that subsidiary analysis. And I think, if I could just get my way back to my note, I think I've said everything I need to say about that. The process is one of looking upwards from the borrower. And most importantly, that was the only basis on which the SFO ever made its case in opposition to the amendments. So it's rather unsatisfactory for my learned friends now to say, oh, well, we oppose the amendments on the basis that the borrowing subsidiaries documents weren't available. But now that we found out the document that they are available, on appeal, we're going to argue that you actually need to look at the sub-subsidiaries documents.
Does that mean the last sentence of paragraph 69 of the judgment was the judge's own view, unsupported by anything in submission?
Yes, my lord, it does. And that's one of our objections on this ground. And if I just finish that off. I've already pointed to the fact that he inserts the word indirect there, which of course is looking to sub-subsidiaries, and that's never in play. If I could ask your lordships to look at this, my learned friend Mr. Hoff's skeleton argument, I'll just deal with the answers he has to why that wasn't an error on the judge's part, if I may. Page 24 of his skeleton, paragraph 61. Because he says the conclusion is unimpeachable. But he's respectfully obviously wrong about that. And it really just picks up the points I've made in answer to your lordship's questions already to some extent. 61.1 and 61.2 assert that the premise of our case for a dollar-to-dollar cost incurred by the Kazakh trading subsidiaries like Kazakh, which are given as the example here, of course is importantly not the company we're dealing with. It is felt as a dollar-for-dollar loss. And they say, therefore, that envy and finance are to be treated as transparent for valuation purposes. Do you see that in the second line of 61.2? Now, that doesn't really, with respect, make any sense, because they are transparent for the valuation purposes, possibly of ENRC, but they're clearly not, it's meaningless if you're asking what the valuation is of envy and finance themselves. You can't, it makes no sense to say that the company being valued is transparent. If you're asking whether NV has a value, you have to ask whether NV has a value. And then one has to ask whether its parent felt that value or not, felt that difference in value or not. So that is no answer, it's actually a straw man. And at 61.3, the transparency point is prayed in aid of a submission that it follows, it is said, that documents held by the sub-subsidiaries would therefore be relevant, and then this rather interesting parenthesis, or at least arguably relevant. And your lordships must, in my submission, look out for that in this document, because we've got to the position where the SFO now says arguable relevance, undecided arguable relevance, is enough to prejudice a fair trial when the decision hasn't been taken as to actual relevance. But be that as it may, it said that that transparency point is the reason why the likes of Cascrone would be relevant to examine why the borrowing costs were as they were. But that is a non sequitur. Of course, a parent company's creditworthiness, whether it's ENRC itself or NV or finance, might be affected by its subsidiaries' affairs. For the reason my lord gave a moment ago, which is that well, you will want to look at what where the cash generation part of the business is and to what risks it's exposed, even if they're not in the parent. Of course that's that, but that's got absolutely nothing to do with whatever you might call transparent nature of the company. That's just a basic fact that when you look at a company with certain assets, and those assets are, in some cases, subsidiaries, one needs to look at the nature of the company's assets. But the idea this stems from some kind of transparency point is really misconceived in my submission. And that takes you back to the point that the SFO has never suggested, and still today does not suggest, for the valuation, for the question of the increased borrowing costs, that you do need to look at any subsidiaries documents. So leave aside dollar for dollar, which I've made my point on, that's an upwards looking point. For what my learned friends are now tackling is whether they NV and finance borrowing costs are higher because of the CI. They have never suggested before to the skeleton that the subsidiaries or the sub-subsidiaries' own documents are relevant to that question. And that is the exact parallel with the claim we've got with ENRC at the moment. That no one is looking at the subsidiaries' documents for ENRC's claim, and so there's no reason to do so for NV or finance's claims. And you'll see that at 61.3, 4 and 5, that is basically the point that is being made, and it's wrong. It's also a non sequitur, of course, to say that because ENRC did accept below, as your lordship put to me, that a lender will look at the overall characteristics of the group, and this is para 61.5, one will have to trawl through the documents held by the subsidiaries and the sub-subsidiaries and the sub-subsidiaries.
It's not a question of how valuable the group in fact was, but how valuable the lenders perceived the group to be.
Yes.
That depends on what the lenders' investigations were.
Yes. All of which is either not in our control to start with or will have been retained because it crossed the line. But more importantly, my lord, if you are asking yourself what is the value of a company to a lender, and the company has 100 subsidiaries, it cannot possibly be a proportionate disclosure exercise to start giving disclosure of all the subsidiaries' internal documents, because that exercise must be capable of being done at a higher level by reference to all of the financial accounts, subsidiaries' financial accounts, what's in the public domain, the credit ratings, and so forth, all of which is available. And so we do know exactly what the lenders were looking at and what they were interested in, as well as what was in the public domain. And no sensible disclosure exercise would go further than that. And as I say, the proof of the pudding is in the eating, because it's not been suggested that one has to go beyond ENRC's own documents to look at the question of whether ENRC's borrowing costs were increased by the criminal investigation. And ENRC is the epitome of the point. It is the company that is at the top of the chain, and it has all of the subsidiaries underneath it. But that means that finance and NV are not functioning in any different position. So the final point that my learned friend makes at paragraph 63.4 is where he tries to answer the judge's reasoning at the end of paragraph 69 of his judgment. And the point here is that we have said, if the judge had raised that point before the judgment, i.e. in argument, we would have given the obvious answer, which is the one I've just given you, which is that it cannot be the case that you need to look at indirect subsidiaries, because you don't need to do that. The ENRC and the SFO don't suggest that you do. The SFO twist that around and say, well, if we'd actually given the answer, it would have been that ENRC's own claim is proceeding to trial despite the litigation hold over many of the subsidiaries, and therefore they pray and aid the comment at paragraph 52 of the judgment, where the judge said the fact there's already a hole in disclosure doesn't mean that it should be allowed to get larger on amendment. And they say, therefore, at the end of 63.4, even if the judge had more fully canvassed his reasoning with ENRC, this would have made no difference to the outcome. But, my lords, that misses the point. That would not have been and is not ENRC's answer. ENRC's answer is not that there might already be a hole, but that the SFO themselves accept that there isn't one. And they have to have accepted that because that's the position we're in on the claim as pleaded for ENRC's borrowing costs. So this argument is an attempt to move the goalposts and obviously to try and get around the fact that there turns out to have been a litigation hold over finance and NV. Those are the reasons, my lords, why ground 4 should be allowed, and they are independent of, or at least in addition to those that I've already outlined. And of course, one of the overlaps is the binary loss for loss issue, dollar for dollar issue. I don't believe that I need to therefore formally move my new evidence application unless my lords have a strong view that they want to look at the structure charts or feel that it's appropriate for me to do so. Maybe I should at least say something about it so your lordship can decide whether to engage with it. It's really in response to that point at 63.4 of the skeleton that I have put these documents in. They say that if the judge had canvassed his unannounced reasoning in the last sentence of paragraph 69 with the ENRC at the hearing, it would have made no difference to the outcome. But that's wrong, because had he said, NV and finance haven't required, to prove NV and finance's increased borrowing costs, you need to look at the subsidiaries. We would have said, first of all, that's not what the SFO's case is. They've never said that. I won't repeat that all over again. But secondly, I would have made the point that if that was so, it would apply to ENRC's own borrowing costs, and it would logically apply to all, or at least an unspecified number of, the dozens and dozens of subsidiaries that exist beyond those who are borrowing companies. And I would have wanted to show him the dozens and dozens of companies that exist within the structure, for the purpose of saying that no judge in the world would, even if that was arguably possibly relevant to the question, have ordered disclosure of subsidiaries' documents, because it would have been a grossly disproportionate task. And insofar as it concerns dollar for dollar, it would be irrelevant, because that looks at upstream transfers, not downstream ones. And that's what the unagreed structure charts were designed to show, that there are more out there. It's that simple, and your lordships will no doubt hear from Mr Hoff as to whether he vigorously opposes you looking at it, and you can make your mind up accordingly.
Well, why don't you give us the reference to where it is?
Yes, my lord, it's in what's called the unagreed documents bundle.
Oh.
And there are only 3 sheets in there, which is an index and 2 pages. And they are should be fold-out A3 coloured charts.
Should we look at it? Well, what we'll do, I think, is look at it now, and then we can hear from Mr Hoff what the objection is.
So you see, we put in 2 charts. One was dated 2014 and one was dated 2015, because that covers some of the relevant period. And you'll find on those charts the companies that we've talked about already today, the actual borrowing companies. And you'll see that, in fact, the shorter chart you've seen is accurate. It's just a subset of this. But if you, for example, one goes below ENRC and Finance and NV to the left-hand side of the page, we have Caschrome, which was a borrower. But Caschrome has at least 6 different subsidiaries itself, 7 if you go into the blue column, and that then feeds down into the further column. And if anyone had suggested at any point that for to ascertain any of the borrowing company's costs, one would need to start looking at its subsidiaries, we would have produced a document like this and said, well, that's just not proportionate. No sensible trial could engage in that process, because all of the financial information ends up coming up to NRC or ERG at the top, and the lenders communicate with them about the information they need to know.
I suppose what would be useful to know sub-subsidiaries are claiming dollar for dollar their increased borrowing losses?
Yes, so the only level of subsidiary that is doing that, well, you'll see probably the easiest thing is the sheet I handed your lordship earlier.
Yeah.
Which is from supplemental bundle page 144.
Yes.
Because that's obviously got a lot less extraneous information. And if you have that alongside, can I suggest page, bear with me one moment. (104) of the document, of the bundle, which is paragraph 38 of our further information on quantum. You'll see the named companies that are borrower companies. And then one can see where they feature in the chart.
Say 104.
Yes, page 104, my lord, it's paragraph 38 of our phase 2 further information. And it lists the borrowers who we rely on, along with ENRC, as the borrowing companies. And we start with ENRC at the top, and then you've got finance, NV, marketing, Shubarkal, aluminium of Kazakhstan, Kazakhstan aluminium smelter, SSGPO, Kazchrome, and EEC Kazakhstan. And if one then goes to the structure chart, you'll see where they feature in the structure chart. So there are a couple, I'm afraid, on the structure chart that are not borrowers, but those ENRC Congo and ENRC Sales Africa, notably. But most of the others are actually borrowers. So most of the borrowing companies, my lord, are what would be called are the first level down from NV, but not all of them. The predominant ones, I think we've given the numbers in our skeleton. Kazchrome and SSGPO, of the trading entities that are sub-subsidiaries below NV,
Yeah.
they account for the vast majority of the lending. And the others get diminishingly smaller as you go along. So obviously their subsidiaries get less and less interesting too. You may also have picked up from our submissions that no matter which entity was formerly the borrower, ENRC was either the borrower or a guarantor of 80% by value of the loans in question. So when the lenders were looking at the strength of covenants and so on, it was generally a question in large part of the ENRC itself being the guarantor for 80% of the loans. Can I just finally make a couple of points in response to finally, I've got only a couple more points. My learned friends say, and this is paragraphs 53.4.2.3 of their skeleton, page 21, that one of the reasons why disclosure of the subsidiaries documents is relevant is to assess whether the company is said to be comparable borrowers for the exercise of the experts assessing what the borrowing rates of other companies were is necessary. And I just wanted to scotch that really at this stage, because the first point is no one's decided that disclosure of the subsidiaries documents is necessary for that purpose, and that's a problem that the judge didn't grapple with and therefore is not capable of being weighed in the balance, whether or not they're right otherwise. But they're not right otherwise, because when the court is assessing the comparability, or an expert is positing the comparability of company A and company B, and looking at whether their attributes justify any conclusions about their respective borrowing rates, no one really would sensibly suggest that the experts would look at anything other than the material available to lenders and the high-level characteristics of the companies to check that they're comparable. You would never need access to a company's the borrowing company's internal emails to assess whether they, for example, to assess whether they're truly comparable companies. And one of the reasons that would be totally pointless is that, of course, we don't have access to the internal emails of the comparator companies, the hypothetical comparators. So if you're asking whether ENRC is borrowing, or Caschrone's borrowing for that matter, is higher or why it's higher or lower than a competitor, it cannot possibly be the case that you have to look at the internal documents of Caschrone as opposed to its characteristics and financial results. Because otherwise you'd have to look at the internal documents of the comparator company. And you can't. It's not possible because they're not within anyone's control. It just rather shows that the SFO's case resorts, in my respectful submission, to these very extreme examples of why there might just be a relevant document out there somewhere that might just say something about an issue that is of conceivable relevance. And they extrapolate that to say, well, now that because you didn't bring your amendments earlier and there's no litigation hold, the trial can't be fair. And the comparables is a good example in my submission of how they just take that far too far. My Lords, unless I can assist you further at this stage, I've used my allocation and I'll...
You're not addressing us on ground 3?
Not separately, my Lord. I don't formally abandon it. You've read what I've read about it. It doesn't add very much weight to the points I've already made.
Well, it's a throwaway comment from the judge, and it seems to me it's a make weight in your appeal, isn't it?
Your Lordship will decide for himself how to view it. The fact I'm not pursuing it may suggest that I don't necessarily disagree. Yes.
You're also not pursuing ground. Well, you haven't said anything orally about ground 5.
You're quite
which
right.
is a slightly more interesting question in terms of general.
Yes. Would you forgive me if I do spend a couple of minutes on that? I'm conscious of the time and I'm confident that we won't be pressed. My learned friends won't be squeezed. You're quite right. I was going to say something about that in the process of saying something about the test generally. On lateness, what I would like to submit is that there is a real risk, if you take my learned friends approach, of what I would call a semantic or circular argument arising. Of course it's the case, my Lords, that the amendments could have been made earlier. Any amendment that doesn't depend on new facts could have been made earlier, by definition, and they happen all the time. But, my Lord, the overarching submission we have is that that does not tell you very much about the question of substance that the court has to grapple with, which is whether the lateness has in fact caused prejudice. And the authorities in fact make it clear that lateness is a label to be used to assist the court to weigh the prejudice that is said to be caused by the lateness, and that's what it goes to.
Well, it's described as a relative term, isn't it?
It is.
And you would say that if it's made at the outset, right at the outset, the quantum phase, it's relatively early.
Yes, it's relatively late if you look at the time when the claim form was issued, but it's relatively early if you look at whether it's impacting on the trial.
And some of the cases draw a distinction between late amendments and very late amendments.
Yes.
Whether it prejudices a trial date and things like that.
Yes.
Or puts unfair pressure on the other side in a run to the trial.
Yes, and one can see that those are in a different category in some cases. And they are treated, because they're labelled very late, there's a much harder, they're given more weight, the prejudice is given more weight. Can I just refer you to the judgment of Lord Justice Burse in ABT Technology, which is in Authorities Bundle tab 9. I think I'd better open the bundle at some point to show you at least one case. But it's a really very short point, because that's at tab 19 of the Authorities Bundle, my Lord, from page 613. And there's just a really short point I want to take from it. You may be familiar, but if not, this was a case where the Court of Appeal concluded that a defendant had deliberately concealed its intended case until it revealed its amendments a few months after the claim was issued. And the effect of that was to deprive the claimant of a legal defence to a counterclaim that it would otherwise have had, which meant it was irredeemably prejudiced. It's a patent case, and you'll see that at paragraph 39 on page 623, that is the upshot of Lord Justice Burse's decision. 39. The right conclusion on the material before the court was that the lateness of the application to amend been deliberately calculated to cause prejudice to the other party and no good reason provided for lateness. Now, this was an amendment, my lord, proposed before pleadings had closed and before the first CMC. So again, in the scheme of things, it was not late in the disruptive sense. It was late because there was a deliberate tactical attempt to block out the claimant's counterclaim, or defence to counterclaim, I should say. And that meant it was late and cried out to be explained, which there was not. So that's clearly at the very end of the spectrum of cases where prejudice is caused by an amendment. And even though it wasn't very late, in the scheme of things, it was relatively late enough to make the prejudice serious. And the point I'd like to show you first is at paragraph 24 of the judge's judgment. The simple point about lateness is that it calls for an explanation justifying the lateness. That is because an amendment which might otherwise be allowed could well be refused if its lateness has caused unjustifiable prejudice to the other party. Therefore, an explanation is needed to work out whether or not it is a case in which, despite the prejudice caused by the lateness, nevertheless the balance comes down in favour of allowing the amendment. So one can see from that, in a sense, he's approaching the relativity point that my lord mentioned.
There does seem to be, in Mr Justice Coulson's judgment, a statement, an amendment is late if it could have been advanced earlier.
Yes.
But that, as you said, really includes pretty well all of them.
Yes. It doesn't actually, on its own, tell you very much. It tells you you're within the normal run of cases where amendments could have been made earlier. And I think if I may say...
And then you go into the question, is there a good reason for it being made late?
Yes.
In this case, you don't have any good reason.
No,
just
not.
think about it.
Yes. Your Lordship put it fairly. But the
But
point...
you say that's not determinative of anything.
Yeah. And the point one gets from this paragraph, my Lord, is that Lord Justice Burst makes that very clear. What he says is that the purpose of asking whether there's a good reason for what is a late amendment isn't to punish someone for not having a good reason. It's because a good reason may go in the balance against the prejudice that is caused by the lateness. What you have to start with is prejudice caused by the lateness. And so the point I'm making is that lateness is relative because all it tells you is you're looking for whether the lateness has caused actual, substantial, weighable prejudice. And what Lord Justice Burst says here is that even if you've got a reason, if the prejudice was unjustifiable, you may not succeed. You still have to have unjustifiable prejudice. So you can't simply say, oh, well, even if there's no prejudice or small prejudice, the absence of a good reason tips the balance in favour of the respondent. You have to weigh.
What's said of paragraph 30, where it refers to lateness as a relative concept. And then at the bottom, mere lateness is unlikely to matter.
Yes. If your Lordship you're quite right. It says, nevertheless, it is important not to focus too much on labels in paragraph 30. And that's the point I was just making. Lateness is lateness, but it doesn't mean anything if it's just a label. Mere lateness is unlikely to matter. The utility in characterising an amendment as late comes from focusing attention on any prejudice caused by the timing and the need for an explanation. So you have 2 points, really. One is that lateness itself is a label. The real question is, what is the prejudice caused by the timing? And a good reason can mitigate the prejudice caused by the timing, but a lack of a good reason does not add any weight to the prejudice. And those are all the points I wanted to make. And if I had to suggest, therefore, that the error the judge made, in a sense, was to assume that because it was late, the absence of a good reason contributed in any real sense to any possible prejudice. It just simply didn't counter any proven prejudice.
Well, the judge's rationale, it seems to me, is this was late, no excuse, and therefore no litigation held which might otherwise have been, and that risks a fair trial.
Yes.
That's
well,
the answer.
We've probably gone back to the first thing your Lordship said to me, and that's a good place to end, because your Lordship's right. The error of principle is failure to identify what that risk was, and whether it was a risk to a fair trial at all, whilst shutting us out from actually having debate about what disclosure was necessary. Those are my submissions.
My Lords, we resist this appeal. The judge applied orthodox legal principles on amendment, which were in fact common ground, and his decision to refuse ENRC's amendments was well within the ambit of reasonable judgment. We'd go further and say it was fully justified. ENRC's grounds mischaracterised both the principles governing amendment and the judge's reasoning, and we say that the ENRC has had to do this because it can't hope to succeed by the alternative route of establishing that the conclusion was outside the wide range of judgment afforded by appeal courts to decisions of this kind. Now I propose to make submissions in the following order if convenient. First of all, some relevant features in the factual and procedural background. Secondly, and briefly, legal principles governing amendment and appellate review of decisions of this kind. And then taking the grounds in the order in which we addressed them in our skeleton. Albeit I think I can now not address ground 3 and be a little shorter on ground 5 than I would have been. In terms of the new evidence application, I was going to deal with that under ground 4, but I'm happy to deal with it now if your lordships wish.
Yes, why don't you tell us now what your objection is? You object to us taking that into account.
Well, the short point is that below, ENRC relied upon the structure chart your lordship saw at page 144 of the supplementary bundle, the simplified one. They didn't at that stage or in their appeal skeleton think that they needed anything more extensive. As a result, we took the position that the application for new evidence failed both the first two Latin-Marshall limbs because the material could have been supplied earlier with reasonable diligence, and it wouldn't have had an important influence on the outcome of the amendment application, given the ENRC didn't choose to raise it either in the hearing below or in the appeal skeleton. Our concern is simply that these are documents which we have not had the opportunity to check with any kind of analysis, and they have been thrown at us rather late in the day. We doubt that very much turns on them, so I don't want to make a great deal of this.
Well, what was before the judge is something described as a simplified structure chart. So it's apparent from that an actual chart would have been much more extensive, and really all that we've now seen is what one might imagine was there anyway.
We don't doubt or dispute that there were many other companies in the group, but what we can't do is accept every detail of this chart. And if
I don't think you're being asked to do that.
But what follows from page 144 is a series of details about shareholdings and so on, and that was in. There's no difficulty with that being in. We just took the position that this was an application that should fail on conventional principles, and we put the case of Tulloch in the bundle to show that those principles remain valid. But as I say, I don't want to die in a ditch over this point, because even on their friend submissions, I don't think it takes them any further.
Thank you.
So dealing then, before I turn to the relevant features of factual and procedural background, may I just make a few initial observations which I hope are uncontroversial. First of all, these disputed amendments could have been made 5 years before, more than 5 years before they were in fact made. No change in circumstances, no reason for the claims not being advanced from the outset as they are now. Secondly, there's no good reason for the amendments being made so late. And as I'll show you, lordships, a little later, ENRC did try to suggest at the outset of the hearing in January that there could be a good reason, that it was justified, but that front collapsed during the hearing, and ENRC confessed to a fundamental mistake. The third point is that ENRC has never sought to dispute that the effect of the lateness is that no litigation hold was placed to prevent destruction or loss of the documents of the operating subsidiaries, nor that many documents of the subsidiaries may have been lost as a result. The ENRC, of course, had the opportunity through evidence to dispute that documents of the subsidiaries had in fact been lost, which might be relevant in to the various categories of disclosure which we had identified in the DRD. But Mr. Pillow suggested that that would have been a disproportionate exercise when he made his submissions to the court. In our submission, that plea to proportionality doesn't sit well with his insistence today upon the enormous value of these claims. The final introduction...
Just understand though, when do you say this broader claim for borrowing costs, it could have been pleaded in 2019? That's what you say?
Certainly could have been pleaded in 2019. And to the extent that this involves amendments to the 2017 proceedings, could have been pleaded at the time of those proceedings.
But we're focusing now on matters going back to 2013.
Yes.
So, on any basis, documents could have been lost in that 6 years anyway.
Well, ENRC had the opportunity to take the point that documents from 2014 to 2016 would have been lost by 2017 or 2019 respectively anyway. That was not a point put through their evidence.
Well, I think their point was that nothing of relevance had been identified as having been destroyed.
Well, their point is that documents of the subsidiaries couldn't be relevant because everything relevant would necessarily have been in the repositories of the parent company, in the repositories of a series of custodians who were all employees.
But surely that in resisting the amendment, isn't there at least an evidential or argumentative burden on you to say that there is some reason to believe that documents which did exist, still existed as of 2019, have ceased to exist after 2019? We just got no way of knowing that.
Well, what provoked the concern about loss of documents was that ENRC pleaded in its own Phase 2 further information that documents, that it was in a difficult position because documents had been lost, or may not have been obtainable, which I think was paragraph 26 of its Phase 2 further information. And that set us on both ourselves and Dechert on the trail of saying, well, have litigation holds been applied? And the answer was litigation holds had not been applied, and the ENRC then made no effort to suggest that the passage of time and the absence of litigation holds was of no effect. Instead, it took upon itself the burden of arguing, of supporting the amendments by saying...
But you accept, do you, that if documents have been lost up to 2019, in other words, in that 6-year period, that wouldn't be a relevant factor in opposing the amendment?
Well, first of all, it isn't necessarily a 6-year period because the claim relates to a period of time from 2013 to 2016, and the first set of proceedings which are sought to be amended is the 2017 proceedings, as well as the 2019 proceedings.
But you couldn't have... I don't understand you to say that you would have been able to object if this claim had been included from the outset in 2019.
We don't say that we would have been able to object if it had been included from the outset, no.
And that's when the litigation hold would be put on.
Well, so suppose a litigation hold is... Ignore for a moment Dechert's interest, because of course Dechert's interests relate to the 2017 proceedings as well. But the...
why would Dechert's interests matter at this point? Well, claims against you.
Because I think because the amendments are sought against Dechert as well in the 2017 proceedings. But even suppose that we're solely concerned with the 2019 proceedings, we've got a period of time for the claim and borrowing costs, which goes from 2013 to 2016. That is a period of 3 years between 2016 and 2019, rather than a period of nearly 9 years between 2016 and the end of 2024, which is when the amendments were
This is all just completely speculative, isn't it, about what documents may have gone missing when?
Well,
I mean, how can one...
that is why our position was that there are categories of documents of the subsidiaries which are relevant, and that we put those forward in our Model C, section 1, the DRD Model C request. And ENRC sought to answer that point by saying documents of this kind could not be relevant, and therefore the amendment could not have had a prejudicial effect. And that's the argument they took before the judge, and which the judge rejected in our submission on entirely sound grounds. Now, ENRC did not choose to say, we have looked into this, and the absence of a document hold wouldn't have made any difference for those categories of documents. And so in circumstances where ENRC now says adverse inferences can serve all our purposes at trial, it would be a little rich for them to say that one should assume in their favour that the litigation hold may have made no difference, despite the fact that they, the only party who could have provided evidence that it hadn't made a difference, that all these documents had been retained, chose not to do so. I see the time. I'm about to move on to the features of factual and procedural background. Before lunch, may I just make this final introductory observation? It is, we say, a surprising proposition for ENRC to advance, as it does, that the court can and should try issues of the ability of specific companies to borrow and the effect on their share price of additional expenses, while acknowledging that there may have been a massive loss of those companies' documents, and saying that those companies' documents simply don't matter. And it's that surprising proposition which I'll return to at 2 p.m.
Yes, very well. We'll say 2 o'clock.
Got my table.